Minnesota real estate deed and title questions. Question 1. For Casey Johnson's first real estate job in Stillwater, who submits the Minnesota salesperson license application after the applicant becomes associated with a broker? Option A. The licensed real estate broker with whom the applicant is associated. Option B. The applicant directly through a personal account only. Option C. The listing client from the applicant's first transaction. Option D. The county recorder in the county where the applicant lives. The correct answer is option A. The licensed real estate broker with whom the applicant is associated. A Minnesota salesperson must be associated with a licensed broker, and the broker submits the license application. The applicant alone does not file the salesperson application, clients have no filing role, and county recorders do not issue salesperson licenses. Broker sponsorship is central to salesperson licensure. Question 2. A Egan parcel contains 8 acres. How many square feet are in the parcel? Option A, $30,750. Option B, $348,480. Option C, $376,975. Option D, $5,056. The correct answer is option B, $348,480. 1 acre contains 43,560 square feet, so acreage is converted by multiplying acres by 43,560. Frontage value, loan amount, and tax amount are calculated from different data. Unit conversion is a common real estate math task. Question 3. For a pre-1978 residential property, what federal disclosure issue should a licensee remember for Blair and Eden Prairie involving a farm parcel priced at $251,500? Option A. The property can never be sold. Option B. Only commercial buyers receive the pamphlet. Option C. Lead-based paint disclosure requirements may apply before the buyer or tenant is obligated. Option D. Lead disclosure replaces all agency disclosure. The correct answer is option C. Lead-based paint disclosure requirements may apply before the buyer or tenant is obligated. Federal lead-based paint rules apply to many pre-1978 residential transactions and require disclosure before the buyer or tenant is obligated. The rules do not ban every sale or limit disclosure to commercial buyers. Lead disclosure is separate from agency disclosure and material fact duties. Question 4. A listing agreement for a Northfield seller is missing a definite end date. Why is that a licensing problem for Cameron in Northfield involving a duplex priced at $355,000? Option A. Listing agreements are valid only if they renew forever. Option B. Expiration dates are allowed only in commercial leases. Option C. The county recorder assigns the expiration date after closing. Option D. Minnesota listing agreements must include a definite expiration date. The correct answer is option D. Minnesota listing agreements must include a definite expiration date. Minnesota listing agreements must be written and include a definite expiration date. Automatic indefinite listings create consumer protection concerns and do not meet the required content rules. County recorders do not supply listing agreement expiration dates. Question 5. A licensee in Rochester wants to know which required continuing education topics must be included in the renewal cycle along with the general module for Kendall in Rochester involving a newly built townhouse priced at $476,000. Option A. Agency law and fair housing. Option B. Only appraisal theory and mortgage underwriting. Option C. Only property insurance and income tax preparation. Option D. Only construction codes and zoning administration. The correct answer is option A. Agency law and fair housing. Minnesota renewal requirements include agency representation and disclosure training and fair housing training as part of the required education mix. Appraisal, insurance, tax, construction, and zoning topics may be useful, but they do not replace those mandated topics. The rule is designed to keep licensees current on representation and anti-discrimination duties. Question 6. A property manager collects rent for an owner in Edina. How should those funds generally be treated before proper disbursement? Option A. as the manager's personal operating funds. Option B, as trust funds handled according to the broker's trust account obligations. Option C, as sales tax collected for the state. Option D, as title insurance premiums. The correct answer is option B, as trust funds handled according to the broker's trust account obligations. Rent collected for an owner is money held for another and must be handled under trust accounting duties. It is not the manager's personal money, a sales tax fund, or a title insurance premium. Property management requires careful separation of client funds. Question 7. A deed gives Finley possession for life, then ownership passes to Quinn Nolan. What interest does Quinn Nolan hold before Finley's death? Option A, leasehold estate. Option B, easement in gross. Option C, remainder interest. Option D, mortgage lien. The correct answer is option C, remainder interest. A remainder interest is a future interest that becomes possessory after a life estate ends. A leasehold is a tenant's possession, an easement in gross is a use right, and a mortgage lien secures debt. The buyer's right follows the life tenant's measuring life. Question 8. If an override clause appears in Blair Garcia's listing agreement, what must the licensee provide within 72 hours after the listing expires for the clause to be effective? Option A, a new deed. Option B, a county tax appeal. Option C, a mortgage payoff statement. Option D, a protective list. The correct answer is option D, a protective list. An override clause is tied to a protective list supplied within the required time after expiration. A deed, tax appeal, or payoff statement does not preserve the broker's override rights. The protective list identifies prospects covered by the clause. Question 9. If Emerson Rivera tells the licensee that the seller will not perform under the signed purchase agreement, what must the licensee do? Option A, immediately disclose the stated intent not to perform to the other party or parties. Option B, keep the information confidential until the closing date. Option C, cancel the agreement without telling the buyer. Option D, disclose only if the seller misses a loan contingency. The correct answer is option A, immediately disclose the stated intent not to perform to the other party or parties. A licensee put on notice that a party will not perform according to the transaction agreement must disclose that intent to the other party or parties. Keeping the information secret would mislead the other side. The rule is different from a party's inability to satisfy a contingency. Question 10. A seller accepts an offer only after the buyer receives financing approval. What type of clause is most likely involved for Emerson and Stillwater involving a vacant lot priced at $326,500? Option A, habendum clause. Option B, financing contingency. Option C, subordination clause. Option D, acceleration clause only. The correct answer is option B, financing contingency. A financing contingency makes performance depend on loan approval or financing terms. A habendum clause appears in deeds, subordination changes lien priority, and acceleration makes a debt due after default. The condition involves financing approval. Question 11. In appraisal, what does highest and best use require for Morgan & Egan involving a townhome priced at $302,500? Option A, the use that produces the highest commission. Option B, the use preferred by the current tenant only. Option C, a use that is legally permissible, physically possible, financially feasible, and maximally productive. Option D, the use with the lowest property tax bill. The correct answer is option C, a use that is legally permissible, physically possible, financially feasible, and maximally productive. Highest and best use considers legal, physical, financial, and productivity tests. Commission, tenant preference, and tax savings alone do not determine highest and best use. The concept focuses on the most supportable use of the property as real estate. Question 12. Two investors own a Bloomington duplex with unequal shares and no survivorship language. Which ownership form is most likely for Casey and Bloomington involving a vacant lot priced at $456,000? Option A, tenancy by the entirety. Option B, severalty. Option C, life tenancy only. Option D, tenancy in common. The correct answer is option D, tenancy in common. Tenancy in common allows unequal ownership shares and has no automatic right of survivorship. Severalty means one owner, and a life tenancy is measured by a life tenancy by the entirety is a special marital form not described by unequal investor shares. Question 13. Which event usually allows trust funds in a Minnesota real estate transaction to be disbursed for Hayden and Brainerd involving a small retail building priced at $227,500? Option A, closing of the transaction, written agreement of the parties, statutory affidavit, or court order. Option B, a verbal request from one salesperson. Option C, a social media announcement that the deal is done. Option D, the buyers hope to renegotiate after closing. The correct answer is option A, closing of the transaction, written agreement of the parties, statutory affidavit, or court order. Trust funds may be disbursed only under recognized authority such as closing, written agreement, applicable statutory affidavit, or court order. A verbal request or social media post does not provide the necessary authority. A buyer's later wish to renegotiate is not a trust fund disbursement event. Question 14. A deed expressly creates survivorship between co-owners of a rental house. Which ownership feature is being emphasized for Avery and Moorhead involving a rental house priced at $218,500? Option A, no right to possess the property. Option B, right of survivorship in joint tenancy. Option C, a tenant's trade fixture right. Option D, a mortgagee's foreclosure priority. The correct answer is option B, right of survivorship in joint tenancy. Joint tenancy is associated with right of survivorship when properly created. Co-owners generally have possession rights, and trade fixtures concern tenants rather than co-owner succession. Mortgage priority is a lien issue, not survivorship ownership. Question 15. A lender must disclose the cost of consumer credit so borrowers can compare loan terms. Which federal law is most directly involved for Rowan and Red Wing involving a lake cabin priced at $292,000? Option A, Sherman Antitrust Act only. Option B, Clean Water Act only. Option C, Truth in Lending Act. Option D, Minnesota Torrens Act only. The correct answer is option C, Truth in Lending Act. Truth in lending requires disclosure of credit terms such as APR in many consumer loans. Antitrust, environmental, and Torrens land registration laws address different areas. The question focuses on loan cost disclosure. Question 16. A loan payment schedule gradually reduces principal until the loan balance reaches zero. What financing term describes this for Finley in Duluth involving a farm parcel priced at $188,000? Option A, accretion. Option B, subordination. Option C, this cheat. Option D, amortization. The correct answer is option D, amortization. Amortization is repayment of a debt through payments that reduce principal over time. Accretion is natural land buildup, subordination changes lien priority, and escheat transfers property to the state when no heirs exist. The decreasing loan balance is the clue. Question 17. Which deed gives Cameron Gwynn the broadest set of title warranties from the grantor? Option A, general warranty deed. Option B, quitclaim deed. Option C, bargain and sale deed with no covenants. Option D, tax certificate only. The correct answer is option A, general warranty deed. A general warranty deed provides the strongest customary covenants of title from the grantor. A quitclaim deed conveys whatever interest the grantor has without warranties. A bargain and sale deed without covenants and a tax certificate provide less assurance than a general warranty deed. Question 18. A broker closes an existing trust account without notice. Why is that a problem under Minnesota trust account rules for Jordan and Mankato involving a lake cabin priced at $392,500? Option A, trust accounts may never be changed under any circumstances. Option B, a broker or closing agent must give written notice to the commissioner before closing an existing trust account. Option C, only buyers can close brokerage trust accounts. Option D. Trust accounts are optional for earnest money. The correct answer is option B. A broker or closing agent must give written notice to the commissioner before closing an existing trust account. Minnesota rules require notice of trust account status changes and written notice before closing an existing account. This does not mean accounts can never change, but they must be properly reported. Buyers do not control brokerage trust accounts, and trust accounts are not optional when trust funds must be held. Question 19. During negotiations in Brainerd, Morgan Okafor changes the price and closing date in the seller's offer. What is the legal effect of that response for Hayden and Brainerd involving a small retail building priced at $276,000? Option A. It is an acceptance because some terms stayed the same. Option B. It creates a lease instead of a purchase contract. Option C. It is a counteroffer that rejects the original offer and proposes new terms. Option D. It keeps the original offer open forever. The correct answer is option C. It is a counteroffer that rejects the original offer and proposes new terms. Changing material terms creates a counteroffer rather than an acceptance. The original offer is rejected unless the offeror renews or accepts the new terms. Keeping some terms unchanged does not preserve the original offer forever or convert the transaction into a lease. Question 20. Why is the Minnesota agency disclosure form given to Sawyer Wilson not enough by itself to create representation? Option A. It automatically creates dual agency for every transaction. Option B. It replaces all purchase agreement requirements. Option C. It gives the consumer a license to sell property. Option D. It is a disclosure only, and representation requires a written listing contract or buyer representation contract. The correct answer is option D. It is a disclosure only, and representation requires a written listing contract or buyer representation contract. The agency disclosure form informs consumers about relationship options but does not create representation. Representation requires a written contract such as a listing agreement or buyer representation contract. The other choices confuse disclosure with dual agency, purchase contracts, or licensing authority. Question 21. What is the main purpose of an owner's title insurance policy for Emerson Kahn? Option A. To protect against covered title defects that existed before the policy date. Option B. To insure the roof against storm damage. Option C. To guarantee future market appreciation. Option D. To replace the need for a purchase agreement. The correct answer is option A. To protect against covered title defects that existed before the policy date. Owner's title insurance protects against covered past title defects, liens, or ownership issues discovered after closing. It is not property casualty insurance, an appreciation guarantee, or a substitute for the purchase contract. Title insurance focuses on ownership risk, not physical damage or investment performance. Question 22. Under Minnesota licensing rules, what happens when a salesperson's association with an actively licensed broker ends for Harper & St. Paul involving a fourplex priced at $214,500? Option A. The salesperson may continue independently for 90 days. Option B. The salesperson's license becomes inactive until proper association is restored. Option C. The salesperson automatically becomes a limited broker. Option D. The salesperson may transfer clients without broker supervision. The correct answer is option B. The salesperson's license becomes inactive until proper association is restored. A salesperson license depends on active association with a licensed broker. Ending that association makes the license inactive, so independent practice is not allowed. Automatic broker status and unsupervised client transfers are not part of the salesperson licensing structure. Question 23. A tenant remains in possession after a lease expires without the landlord's consent. What is the tenant's status for Sawyer in Maple Grove involving a duplex priced at $213,000? Option A. Remainderman. Option B. Joint tenant. Option C. Tenant at sufferance. Option D. Dominant tenant. The correct answer is option C. Tenant at sufferance. A tenant at sufferance is a holdover who originally had lawful possession but stays without consent after the right ends. A remainderman holds a future interest, a joint tenant is a co-owner, and dominant tenant is not the standard term. The holdover fact controls. Question 24. A Woodbury salesperson asks whether Minnesota state law or a private study guide controls if they conflict. Which source governs? Option A. The private study guide controls if newer. Option B. A salesperson's office custom controls. Option C. The buyer's preferred answer controls. Option D. Minnesota law governs the licensing issue. The correct answer is option D. Minnesota law governs the licensing issue. Official guidance makes clear that Minnesota law governs licensing issues. Study guides and office customs are learning tools or business practices, not controlling law. A buyer's preference cannot override statutory requirements. Question 25. An advertisement says a condominium unit is available only for adults with no children. What is the main fair housing concern for Emerson in Stillwater involving a condominium unit priced at $352,500? Option A. The statement indicates a preference or limitation based on familial status. Option B. The ad forgot to mention the roof age. Option C. The ad uses a list price instead of an appraised value. Option D. The ad includes the city name. The correct answer is option A. The statement indicates a preference or limitation based on familial status. Advertising cannot indicate a discriminatory preference or limitation based on familial status except where a valid housing for older persons exemption applies. Roof age, list price, and city name are not the fair housing issue in the wording. The problem is discouraging families with children. Question 26. A seller instructs the licensee not to disclose a known structural defect to buyers. Which principle controls for Kendall and Rochester involving a townhome priced at $468,500? Option A. The licensee must obey every instruction from a client. Option B. The licensee cannot obey unlawful instructions that conflict with required disclosure duties. Option C. The defect becomes confidential forever. Option D. The buyer's broker alone must discover every defect. The correct answer is option B. The licensee cannot obey unlawful instructions that conflict with required disclosure duties. Obedience applies only to lawful instructions. A client cannot require a licensee to hide a material fact that law requires to be disclosed. The duty to disclose known material defects is not shifted entirely to the buyer's broker. Question 27. A garage built on Harper Davis's land extends 2 feet over the boundary onto a neighbor's parcel. What issue is created? Option A. Hypothecation. Option B. Subrogation. Option C. Encroachment. Option D. Reconciliation. The correct answer is option C. Encroachment. An encroachment occurs when an improvement physically intrudes onto another parcel. Hypothecation pledges property for debt. Subrogation substitutes one party's claim, and reconciliation is an appraisal conclusion step. The garage crossing the boundary is the key fact. Question 28. Why would an appraiser rely heavily on the cost approach for a newly built duplex in St. Paul? Option A. It ignores land value completely. Option B. It is the only legal method for all residential property. Option C. It values the property only by monthly rent. Option D. Replacement cost and depreciation can be estimated more reliably for new improvements. The correct answer is option D. Replacement cost and depreciation can be estimated more reliably for new improvements. The cost approach is useful for new construction because replacement cost and accrued depreciation can be estimated with less uncertainty. It still includes land value and is not the only legal method for every property. Monthly rent belongs to income analysis rather than cost analysis. Question 29. In a lien theory mortgage state such as Minnesota, what does the mortgage usually give the lender for Sawyer in Maple Grove involving a rental house priced at $317,000? Option A. A lien securing repayment while the borrower retains title. Option B. Immediate ownership and possession of the property. Option C. A life estate measured by the borrower's life. Option D. A leasehold estate for the loan term. The correct answer is option A. A lien securing repayment while the borrower retains title. In lien theory, the mortgage gives the lender a security lien rather than immediate title and possession. The borrower retains legal title unless foreclosure changes ownership. Life estates and leaseholds are different interests, not the ordinary mortgage relationship. Question 30. Why should a purchase agreement for a small retail building in Egan be in writing and signed by the party to be charged for Morgan in Egan involving a small retail building priced at $370,500? Option A. All oral contracts are criminal offenses. Option B. The statute of frauds requires most real estate sale contracts to be in writing to be enforceable. Option C. Only lenders may sign real estate contracts. Option D. A deed is unnecessary if the parties shake hands. The correct answer is option B. The statute of frauds requires most real estate sale contracts to be in writing to be enforceable. The statute of frauds generally requires contracts for the sale of real property to be in writing and signed by the party to be charged. Oral agreements may fail enforceability even if the parties intended a deal. Lender-only signatures and handshake transfers do not replace the required written contract and later conveyance documents. Question 31. A Moorhead listing agreement omits the real property description. What required element is missing? Option A. The buyer's credit score. Option B. The lender's underwriting model. Option C. A description of the real property involved. Option D. The appraiser's license number. The correct answer is option C. A description of the real property involved. Minnesota listing agreements must describe the real property involved. A buyer's credit score, underwriting model, or appraiser license number is not a required listing agreement element. The contract must identify the property being offered. Question 32. In Rochester, a new applicant asks which combination best describes the salesperson licensing path in Minnesota for Kendall in Rochester involving a small retail building priced at $347,500. Option A. Be at least 21, complete only course I, and work independently after passing the exam. Option B. Complete continuing education before any pre-license education and apply directly without a broker. Option C. Pass only the national exam and begin practicing while the application is pending. Option D. Be at least 18, complete courses 1, 2, and 3, pass the exam, associate with a broker, and receive Commerce Department approval. The correct answer is option D. Be at least 18, complete courses 1, 2, and 3, pass the exam, associate with a broker, and receive Commerce Department approval. Minnesota salesperson licensing requires age eligibility, 3 30-hour pre-license courses, examination success, broker association, and approval by the Commerce Department. The other choices either remove required courses, allow independent practice, or treat a pending application as authority to act. Those alternatives do not satisfy the licensing sequence. Question 33. A lot has 125 front feet worth $210 per front foot. What is the indicated front foot value? Option A, $26,250. Option B, $1,696. Option C, $12,292. Option D, $840,000. The correct answer is option A, $26,250. Front foot valuation multiplies frontage by the price per front foot. Tax prioration, commission, and income capitalization rely on other formulas. The question asks only for the land value indicated by frontage. Question 34. A social media ad for a fourplex in St. Cloud uses a team name. What must the advertisement clearly and conspicuously display for Taylor in St. Cloud involving a fourplex priced at $432,500? Option A. Only the salesperson's nickname. Option B. The real estate brokerage name. Option C. Only the property street address. Option D. Only the team logo without the brokerage. The correct answer is option B. The real estate brokerage name. Minnesota advertising rules require the brokerage name to be clearly and conspicuously displayed. A team name may be used only with broker authorization and the brokerage name still must appear. Nicknames, street addresses, and logos do not replace the required brokerage identification. Question 35. At Cedar Realty, a salesperson asks which online system the Commerce Department uses for many licensing services such as applications, renewals, and transfers for Hayden and Brainerd involving a small retail building priced at $288,500. Option A, MLS Grid. Option B, Torrens Online. Option C, Pulse. Option D, HUD Exchange. The correct answer is option C, Pulse. Pulse is the electronic licensing system used for many Minnesota Commerce Department licensing services. MLS systems, Torrens records, and HUD resources serve different purposes. Knowing the licensing portal helps distinguish administrative filing from transaction records and federal housing resources. Question 36. If a seller rejects Rowan Johnson's offer and the listing broker holds the earnest money, when should the rejected offer's earnest money be returned? Option A. Only after the seller signs a different purchase agreement. Option B. At the end of the listing period. Option C. After the broker deducts marketing expenses. Option D. No later than the next business day after rejection. The correct answer is option D. No later than the next business day after rejection. When an offer is rejected, Minnesota trust account rules require earnest money to be returned to the potential buyer no later than the next business day after rejection. The broker cannot hold it until another sale, listing expiration, or reimbursement of marketing costs. Rejected offers do not create a right to keep the buyer's funds. Question 37. A Prairie Realty branch office wants licensees to access current Minnesota statutes and rules electronically. Is electronic access acceptable for Taylor and St. Cloud involving a fourplex priced at $363,000? Option A. Yes, access to required statutes and rules may be made available electronically. Option B. No, only a paper binder signed by every buyer is allowed. Option C. Yes, but only if clients pay a records fee. Option D. No, statutes are never required in real estate offices. The correct answer is option A. Yes, access to required statutes and rules may be made available electronically. Minnesota standards allow access to required statutes and rules through an electronic agent. A paper-only rule, client fee requirement, or no access approach misstates the standard. The point is that licensees must have current legal resources available. Question 38. A licensee in Eagan drafts a complex legal clause for Skylar Thompson instead of recommending legal counsel. What risk is created? Option A. Constructive eviction. Option B. Unauthorized practice of law. Option C. Functional obsolescence. Option D. Inverse condemnation. The correct answer is option B. Unauthorized practice of law. Licensees may fill in approved forms and explain business terms, but drafting legal clauses can cross into unauthorized practice of law. Constructive eviction, functional obsolescence, and inverse condemnation describe different legal or valuation issues. Complex legal drafting should be handled by an attorney. Question 39. A buyer includes an inspection condition in a Brainerd purchase agreement. What is the role of that contingency? Option A. It automatically transfers title to the buyer. Option B. It eliminates the need for earnest money accounting. Option C. It makes the buyer's duty to perform depend on the stated inspection condition being satisfied or waived. Option D. It makes the broker a home inspector. The correct answer is option C. It makes the buyer's duty to perform depend on the stated inspection condition being satisfied or waived. A contingency is a condition that must be satisfied, waived, or otherwise resolved for the contract obligations to proceed as written. It does not transfer title or remove trust accounting duties. The broker does not become the inspector merely because the contract contains an inspection contingency. Question 40. A borrower signs a promissory note and mortgage to finance a St. Cloud home. What does the note do for Taylor and St. Cloud involving a rental house priced at $418,500? Option A, transfers title to the lender at closing. Option B, sets the zoning classification. Option C, records the deed tax payment. Option D, creates the borrower's personal promise to repay the debt. The correct answer is option D, creates the borrower's personal promise to repay the debt. The promissory note is the borrower's promise to repay according to the loan terms. The mortgage secures that promise with a lien on the property. Zoning, title transfer, and deed tax are separate matters. Question 41. A buried heating oil tank is discovered during inspection of a townhome. Why is this important for Skylar in Blaine involving a townhome priced at $340,000? Option A, underground storage tanks can create environmental and cleanup concerns that may affect value and use. Option B, they automatically convert the property to personal property. Option C, they prove the deed is forged. Option D, they eliminate all mortgage requirements. The correct answer is option A. Underground storage tanks can create environmental and cleanup concerns that may affect value and use. Underground storage tanks may involve leaks, regulatory requirements, and cleanup costs, making them material environmental concerns. They do not convert real estate into personal property, prove deed fraud, or remove financing requirements. Environmental issues can affect value, marketability, and buyer decisions. Question 42. Under Minnesota law, which statute is the primary source for real estate broker and salesperson regulation for Morgan & Egan involving a small retail building priced at $216,000? Option A, Minnesota Statutes Chapter 287 only. Option B, Minnesota Statutes Chapter 82. Option C, the Federal Internal Revenue Code only. Option D, a local MLS policy manual only. The correct answer is option B, Minnesota Statutes Chapter 82. Chapter 82 governs real estate brokers and salespersons in Minnesota. Chapter 287 covers deed tax and mortgage registry tax topics, and federal tax law or MLS policies do not replace state licensing law. Exam questions often test which authority controls licensing conduct. Question 43. Regarding commission language in a Minnesota listing agreement, which statement best reflects the required consumer notice for Cameron in Northfield involving a fourplex priced at $422,000? Option A. The state sets one mandatory commission rate for all residential listings. Option B. The MLS sets the minimum commission for every listing. Option C. Compensation is determined between each individual broker and the broker's client. Option D. The buyer must always pay the listing broker directly. The correct answer is option C. Compensation is determined between each individual broker and the broker's client. Minnesota listing agreements must include a notice that compensation is determined between the broker and the broker's client. The state and MLS do not set a universal commission rate for every transaction. Payment arrangements depend on the agreement and cannot be assumed from the listing alone. Question 44. A rumor says a Bemidji home was once the site of a natural death and possible paranormal activity. Under Minnesota disclosure rules, how is that fact treated? Option A. It must always be disclosed in the listing contract. Option B. It makes the property unmarketable until court approval. Option C. It requires the buyer to receive a separate environmental report. Option D. It is not treated as a material fact that must be disclosed merely for that reason. The correct answer is option D. It is not treated as a material fact that must be disclosed merely for that reason. Minnesota law states that certain stigmatizing facts, such as suicide, natural death, or perceived paranormal activity, are not material facts requiring disclosure merely because they occurred. That does not change the duty to disclose physical defects or other material facts. Listing contracts, court approval, and environmental reports address different issues. Question 45. A landlord in Woodbury deducts from a security deposit for unpaid rent and damage beyond ordinary wear and tear. What makes those deductions more defensible for Riley in Woodbury involving a mixed-use property priced at $461,500? Option A. They are tied to permitted reasons and supported by a written explanation. Option B. They are based only on the landlord's dislike of the tenant. Option C. They include normal fading of paint from ordinary use. Option D. They are taken without notice because deposits are always non-refundable. The correct answer is option A. They are tied to permitted reasons and supported by a written explanation. Minnesota security deposit deductions are generally tied to unpaid obligations or damage beyond ordinary wear and tear, with a written explanation when money is withheld. Personal dislike, normal wear, and treating every deposit as non-refundable are not defensible bases. Documentation is essential in landlord-tenant accounting. Question 46. A listing contract says it may be cancelled only under certain stated conditions. Why does that matter for Taylor in St. Cloud involving a duplex priced at $397,500? Option A. Cancellation terms are never allowed in listing agreements. Option B. Minnesota listing agreements must explain whether cancellation is allowed and the terms for cancellation. Option C. Only the buyer may cancel a seller's listing. Option D. The broker can cancel only by recording a deed. The correct answer is option B. Minnesota listing agreements must explain whether cancellation is allowed and the terms for cancellation. Minnesota listing agreements must include a clear statement explaining if the agreement may be cancelled and the cancellation terms. The issue is contract clarity, not deed recording or buyer control. Stated cancellation terms help prevent disputes. Question 47. When Sawyer Okafor buys a condominium unit in St. Paul, what does the buyer typically own? Option A. Only a stock certificate and no real property interest. Option B. The entire building in severalty. Option C. The individual unit plus an undivided interest in the common elements. Option D. A temporary license to occupy the unit. The correct answer is option C. The individual unit plus an undivided interest in the common elements. Condominium ownership generally includes the individual unit and an undivided interest in common elements. A cooperative usually involves shares and a proprietary lease, not condominium ownership. The buyer does not own the whole building alone or merely hold a temporary license. Question 48. A buyer's lender evaluates income, credit, and property value without discrimination. Which law commonly governs equal access to credit for Riley in Woodbury involving a single-family home priced at $272,500? Option A. Statute of Frauds. Option B. Truth in Zoning Act. Option C. Rule against perpetuities only. Option D. Equal Credit Opportunity Act. The correct answer is option D. Equal Credit Opportunity Act. The Equal Credit Opportunity Act prohibits discrimination in credit transactions based on protected characteristics. The statute of frauds concerns enforceability of certain contracts, and zoning or perpetuity concepts are unrelated to lending equality. Financing decisions must focus on lawful underwriting factors. Question 49. A Bemidji salesperson wants to place personal money in the broker trust account to save for taxes. Why is that improper for Quinn in Bemidji involving a vacant lot priced at $321,000? Option A. Trust accounts may contain only trust funds except limited identified funds for service charges or minimum balance requirements. Option B. Personal funds must always be kept in the listing broker's trust account. Option C. Salespersons may use trust accounts as savings accounts with broker consent. Option D. Commingling is allowed when the amount is less than 1 month's rent. The correct answer is option A. Trust accounts may contain only trust funds except limited identified funds for service charges or minimum balance requirements. Trust accounts are for trust funds, with only limited identified personal funds allowed for service charges or minimum balance requirements. Using the account as a personal savings account would commingle funds. Broker consent or a small amount does not change the commingling rule. Question 50. Before advertising Cameron Patel's lake cabin to the general public, what must a Minnesota licensee obtain? Option A. An oral promise that the owner may list later. Option B. A signed listing agreement or other signed written authorization from the owner or authorized person. Option C. A buyer's pre-approval letter. Option D. A tax parcel map from the county. The correct answer is option B. A signed listing agreement or other signed written authorization from the owner or authorized person. A licensee must have a signed listing agreement or other signed written authorization before advertising real property for sale or lease to the general public. Oral permission is not enough for this requirement. Buyer pre-approval and tax maps may be useful, but they do not authorize public advertising. Question 51. At the end of a Minnesota tenancy, what must a landlord generally do with the tenant's security deposit after receiving a forwarding address for Hayden and Brainerd involving a townhome priced at $470,500? Option A. Keep the entire deposit automatically as a cleaning fee. Option B. Apply the deposit to the broker's commission. Option C. Return the deposit plus interest or provide a written explanation of lawful deductions within the required time. Option D. Record the deposit with the county as a deed restriction. The correct answer is option C. Return the deposit plus interest or provide a written explanation of lawful deductions within the required time. Minnesota law requires the landlord to return the deposit with interest or provide a written explanation for lawful deductions within the required period. Automatic forfeiture, commission payment, and county deed restrictions do not match the security deposit rules. Security deposits remain tenant funds unless a lawful deduction applies. Question 52. An easement benefits a neighboring parcel by allowing driveway access across Jordan Lee's land. What type of easement is most likely? Option A. Personal license only. Option B. Trade fixture. Option C. A mechanic's lien. Option D. Easement appurtenant. The correct answer is option D. Easement appurtenant. An easement appurtenant benefits another parcel and usually runs with the land. A personal license is revocable permission, a trade fixture is tenant property, and a mechanic's lien secures payment for improvements. The presence of a benefited parcel points to an appurtenant easement. Question 53. Which Minnesota tax is generally associated with recording a deed that conveys real property for Hayden and Brainerd involving a townhome priced at $295,000? Option A. State deed tax. Option B. Mortgage registry tax only. Option C. Utility franchise fee. Option D. Federal gift tax return fee. The correct answer is option A. State deed tax. Deed tax is generally associated with recording a deed conveying real property. Mortgage registry tax relates to mortgage debt, while utility franchise and federal gift tax issues are outside the ordinary deed recording charge. The transaction document determines which tax applies. Question 54. A buyer transfers contract rights to another buyer but remains liable unless released. What is this called for Cameron in Northfield involving a duplex priced at $331,000? Option A. Novation with automatic release. Option B. Assignment. Option C. This cheat. Option D. Ad valorem taxation. The correct answer is option B. Assignment. Assignment transfers contractual rights to another party, but the assignor can remain liable unless a release or novation occurs. Escheat and ad valorem taxation are unrelated. The distinction between assignment and novation is commonly tested. Question 55. A borrower gives a mortgage on a Northfield property while retaining possession. What financing concept lets the borrower pledge the property without surrendering it for Cameron in Northfield involving a rental house priced at $205,000? Option A. Avulsion. Option B. Emblements. Option C. Hypothecation. Option D. Accession. The correct answer is option C. Hypothecation. Hypothecation means pledging property as security for a debt while retaining possession. Avulsion and accession concern land or property changes, while emblements are crops. Mortgage lending commonly uses hypothecation. Question 56. A lender offers Emerson Nolan a mortgage whose interest rate can change based on an index after an initial period. What type of loan is this? Option A. Package mortgage only. Option B. Open-end listing. Option C. Graduated lease. Option D. Adjustable rate mortgage. The correct answer is option D. Adjustable rate mortgage. An adjustable rate mortgage has an interest rate that may change according to an index and loan terms. A package mortgage includes personal property, an open-end listing is not a standard listing type, and a graduated lease changes rent over time. The index-based interest change identifies the loan type. Question 57. Unless the parties' written agreement says otherwise, when should a Minnesota listing broker deposit earnest money after receiving it and final acceptance has occurred for Rowan and Red Wing involving a single-family home priced at $364,500? Option A. Within 3 business days of receipt or final acceptance, whichever is later. Option B. Only after the buyer's loan is fully underwritten. Option C. At any time before the deed is recorded. Option D. Within 30 calendar days after the first showing. The correct answer is option A. Within 3 business days of receipt or final acceptance, whichever is later. Minnesota trust account rules provide a default deadline of 3 business days after receipt or final acceptance, whichever is later, when the written agreement is silent. Waiting for underwriting, recording, or an arbitrary 30-day period would not meet that default rule. The parties can address timing in their written agreement. Question 58. Before Reese schedules the salesperson examination after studying in Woodbury, which pre-license course must already be completed? Option A, Course 2 only. Option B, Course I. Option C, Course 3 only. Option D, the annual continuing education module. The correct answer is option B, Course I. Course I must be successfully completed before a candidate registers for the salesperson examination. Course 2 and Course 3 are required before license application, while the annual module is a continuing education requirement for licensees. Confusing pre-license and continuing education rules leads to the wrong result. Question 59. While interviewing with 2 firms in Rochester, Kendall asks how many Minnesota brokers may supervise the salesperson during the same period. Option A. 2 brokers if both brokers consent. Option B. Any number of brokers if the salesperson discloses the arrangement. Option C. 1 actively licensed broker. Option D. 1 broker for residential sales and a separate broker for leases. The correct answer is option C. 1 actively licensed broker. A salesperson in Minnesota is licensed to act on behalf of 1 broker during the same period. Consent or disclosure does not create authority to work under multiple brokers. Splitting residential and leasing work between brokers would still violate the Single Broker Association rule. Question 60. A broker learns that a foundation defect could significantly affect Cameron Okafor's use of a rental house in St. Cloud. What should the broker do? Option A. Stay silent because the defect might reduce the seller's price. Option B. Disclose only after closing if the buyer complains. Option C. Treat the defect as confidential even if it affects use and enjoyment. Option D. Disclose the material fact to the prospective purchaser. The correct answer is option D. Disclose the material fact to the prospective purchaser. Known material facts that could adversely and significantly affect an ordinary buyer's use or enjoyment must be disclosed. Protecting a sale price does not excuse non-disclosure, and waiting until after closing defeats the purpose of the rule. Confidentiality does not cover facts that law requires to be disclosed. Question 61. If assessed value is $246,150 and the tax rate is 12 mils, what is the annual property tax? Option A, $2,954. Option B, $1,066. Option C, $5,812. Option D, $41,025. The correct answer is option A, $2,954. A mil is $1 per $1,000 of assessed value, so the tax is assessed value multiplied by mils divided by 1,000. Monthly interest, points, and down payment are financing calculations. Millage questions require converting mils to a decimal rate. Question 62. A lender draws a line around a Ramsey neighborhood and refuses otherwise qualified mortgage applicants there. What fair housing and lending term best fits for Avery in Moorhead involving a duplex priced at $207,500? Option A, plottage. Option B, redlining. Option C, accretion. Option D, estoppel. The correct answer is option B, redlining. Redlining is denying or limiting credit in an area for discriminatory reasons rather than evaluating individual qualifications. Plottage relates to value from assemblage, accretion is natural land buildup, and estoppel prevents inconsistent claims. Area-based discriminatory lending violates fair lending principles. Question 63. Under Chapter 82 Standards, what must a broker do to properly supervise salespersons at a Mankato office for Jordan in Mankato involving a single-family home priced at $338,500? Option A. Let each salesperson approve their own contracts without broker review. Option B. Delegate all trust records to buyers and sellers. Option C. Monitor brokerage activities, review transaction documents, and review trust account books and records. Option D. Supervise only advertising and ignore purchase agreements. The correct answer is option C. Monitor brokerage activities, review transaction documents, and review trust account books and records. Broker supervision includes ongoing monitoring of salespersons, transaction documents, and trust account records. Salespersons do not self-supervise, and clients are not responsible for brokerage trust accounting. Limiting supervision to advertising would miss major broker responsibilities. Question 64. During a St. Paul license renewal review, which continuing education schedule best matches Minnesota salesperson requirements for Harper and St. Paul involving a rental house priced at $449,500? Option A. 10 hours every 4 years with no annual deadline. Option B. 30 hours only during the first licensing year. Option C. Only the required module with no other continuing education. Option D. 30 hours before the June 30th renewal deadline, with at least 15 hours completed before the previous June 30th. The correct answer is option D. 30 hours before the June 30th renewal deadline, with at least 15 hours completed before the previous June 30th. Minnesota salespersons generally need 30 hours of continuing education before the June 30th renewal deadline, with at least 15 hours due before the previous June 30th. The other options understate the hours, remove the annual structure, or treat the module as the only requirement. Continuing education must be completed in the proper license period. Question 65. If Reese fails to complete required continuing education by the renewal deadline, what license consequence can occur for Reese in Edina involving a mixed-use property priced at $258,000? Option A. The license can become inactive. Option B. The license automatically converts to a broker license. Option C. The license becomes a deed restriction. Option D. The license renews for free without further action. The correct answer is option A. The license can become inactive. Failure to complete continuing education before the deadline can cause a Minnesota real estate license to become inactive. It does not upgrade the license, affect title to property, or waive renewal obligations. Continuing education is a condition of maintaining active status. Question 66. A buyer receives a qualified third-party inspection report, but the licensee knows a fact that contradicts it. What must the licensee do for Cameron in Northfield involving a duplex priced at $414,000? Option A. Stay silent because the report always controls. Option B. Disclose known facts that contradict the report. Option C. Destroy the report and order a new one. Option D. Tell only the inspector after closing. The correct answer is option B. Disclose known facts that contradict the report. A licensee may rely on a qualified third-party report unless the licensee knows facts that contradict it. Known contradictions must be disclosed to the parties. Silence, destruction of the report, or delayed notice would undermine the disclosure duty. Question 67. A buyer takes title while the seller's existing loan remains in place, but the buyer does not become personally liable to the lender. What phrase best describes this for Parker and Winona involving a newly built townhouse priced at $230,000? Option A. Assuming the mortgage with release. Option B. Creating a life estate. Option C. Taking subject to the mortgage. Option D. Recording a quitclaim covenant. The correct answer is option C. Taking subject to the mortgage. Taking subject to a mortgage means the property remains security for the debt, but the buyer does not personally promise the lender to pay. Assumption involves personal liability unless otherwise released. Life estates and quitclaim covenants are unrelated to this financing arrangement. Question 68. Before negotiating a purchase involving a licensee's sibling as a principal, what should the licensee do for Blair in Eden Prairie involving a condominium unit priced at $316,000? Option A. Say nothing because relatives are not licensees. Option B. Disclose only after the commission is paid. Option C. Ask the lender to disclose it instead. Option D. Disclose the relationship in writing before negotiating or consummating the transaction. The correct answer is option D. Disclose the relationship in writing before negotiating or consummating the transaction. Minnesota requires written disclosure when a principal is a licensee's relative or business associate. Waiting until after commission payment is too late, and the duty is not shifted to the lender. The rule protects parties from undisclosed conflicts of interest. Question 69. A listing agreement states the commission amount but does not explain what event earns it. What required item is missing for Quinn in Bemidji involving a condominium unit priced at $432,500? Option A. A clear statement of the events or conditions that entitle the broker to a commission. Option B. A promise that the buyer will waive inspection. Option C. A surveyor's certification for every sale. Option D. A court order approving the commission. The correct answer is option A. A clear statement of the events or conditions that entitle the broker to a commission. Minnesota listing agreements must explain the events or conditions that entitle the broker to compensation. Inspection waivers, surveyor certifications, and court orders are not substitutes for commission earning terms. Clear compensation triggers protect both broker and client. Question 70. A pooled interest-bearing trust account earns interest on client funds, unless otherwise agreed. Where is the interest generally paid under Minnesota rules for Cameron in Northfield involving a rental house priced at $456,000? Option A. To the salesperson as a bonus. Option B. To the Minnesota Housing Finance Agency for the Housing Trust Fund account. Option C. To the listing client automatically. Option D. To the county assessor's operating budget. The correct answer is option B. To the Minnesota Housing Finance Agency for the Housing Trust Fund account. Minnesota rules direct interest from pooled trust accounts, less reasonable costs, to the Minnesota Housing Finance Agency for the Housing Trust Fund account unless the parties specify otherwise. The salesperson, listing client, and county assessor are not the default recipients. Trust account interest is regulated separately from commission. Question 71. Which appraisal approach is usually most persuasive for a typical owner-occupied home in a subdivision with many recent comparable sales for Taylor and St. Cloud involving a duplex priced at $332,000? Option A. Cost approach only. Option B. Income approach only. Option C. Sales comparison approach. Option D. A front foot method only. The correct answer is option C. Sales comparison approach. The sales comparison approach is usually strongest when similar properties have sold recently in the same market. The cost approach can be useful for new or special purpose improvements, and the income approach is more relevant to income-producing property. Front foot analysis is a land valuation tool, not the main method for a typical home. Question 72. Which lease gives a tenant possession for a fixed term that ends automatically on the stated expiration date for Harper in St. Paul involving a duplex priced at $303,000? Option A. Tenancy at sufferance. Option B. Fee simple defeasible. Option C. Easement appurtenant. Option D. The estate for years. The correct answer is option D. Estate for years. An estate for years is a leasehold for a definite period and ends at the stated expiration. Tenancy at sufferance is holdover possession after lawful possession ends. Fee simple defeasible and easement appurtenant are not ordinary fixed-term leasehold estates. Question 73. If one broker represents both Reese Okafor and Morgan Gwynn in a residential transaction, what must occur before the broker acts as a dual agent? Option A. All parties must give informed consent to the dual agency relationship. Option B. Only the seller must consent because the seller listed the property. Option C. The broker may proceed without consent if the commission is reduced. Option D. Consent is unnecessary if two different salespersons are involved. The correct answer is option A. All parties must give informed consent to the dual agency relationship. Dual agency requires informed consent from the parties because the broker owes duties to both sides and cannot advocate exclusively for either one. A lower commission does not remove the conflict, and two salespersons licensed to the same broker can still create dual agency. Seller-only consent is not enough. Question 74. Recording a deed for a lake cabin in Hennepin County primarily gives what type of notice to the public? Option A. Private notice only to the buyer's lender. Option B. Constructive notice. Option C. A zoning variance. Option D. A guarantee of physical condition. The correct answer is option B. Constructive notice. Recording places an instrument in the public records and gives constructive notice of the recorded interest. It does not create a zoning variance or guarantee the property's physical condition. The public records system protects priority and notice, not building quality. Question 75. A residential buyer has not signed a representation contract. How should the licensee describe the buyer's status after agency disclosure for Avery in Moorhead involving a duplex priced at $403,500? Option A. The buyer is automatically a client forever. Option B. The buyer becomes the broker's employee. Option C. The buyer is a customer unless and until a written representation contract is signed. Option D. The buyer receives ownership rights in the brokerage. The correct answer is option C. The buyer is a customer unless and until a written representation contract is signed. Minnesota agency disclosure explains that a consumer is not represented until a written representation contract is signed. Customer status is different from client representation. Employment and ownership rights are not created by receiving agency disclosure. Question 76. Under federal fair housing law, which group is a protected class in the sale or rental of housing for Schuyler and Blaine involving a newly built townhouse priced at $315,000? Option A. Credit score above 700. Option B. Preference for lakefront homes. Option C. Employment in real estate sales. Option D. Familial status. The correct answer is option D. Familial status. Familial status is a protected class under federal fair housing law. Credit score, housing preferences, and occupation in real estate are not protected classes by themselves. Housing decisions must avoid discrimination based on protected characteristics. Question 77. A retail tenant pays base rent plus a percentage of monthly sales. What lease type is described for Avery in Moorhead involving a rental house priced at $333,500? Option A. Percentage lease. Option B. Ground lease only. Option C. Graduated deed. Option D. Quitclaim lease. The correct answer is option A. Percentage lease. A percentage lease includes rent based partly on the tenant's sales, commonly in retail settings. A ground lease involves leasing land, and the other terms are not standard lease classifications. The sales volume rent formula is the key clue. Question 78. A salesperson tells owners in Mankato to sell quickly because people from a protected class are moving nearby. What prohibited practice does this describe for Jordan in Mankato involving a lake cabin priced at $239,500? Option A. Reconciliation. Option B. Blockbusting. Option C. Hypothecation. Option D. Assemblage. The correct answer is option B. Blockbusting. Blockbusting uses fear or panic about protected class changes to induce owners to sell or rent. Reconciliation is an appraisal step, hypothecation pledges property as loan security, and assemblage combines parcels. The key issue is discriminatory pressure on owners. Question 79. At closing, why are prepaid property taxes or rents commonly prorated between buyer and seller for Schuyler and Blaine involving a townhome priced at $420,500? Option A. To change the sales price after acceptance. Option B. To avoid recording the deed. Option C. To allocate income or expenses to the party who owned the property during the relevant time period. Option D. To eliminate the need for title insurance. The correct answer is option C. To allocate income or expenses to the party who owned the property during the relevant time period. Prorations allocate recurring income and expenses based on the period each party is entitled to or responsible for them. They do not rewrite the price, avoid recording, or replace title insurance. Closing statements use debits and credits to make this allocation. Question 80. If Emerson passes the salesperson examination on a spring test date, how long does the candidate generally have to apply for the license before retaking the exam is required for Emerson in Stillwater involving a farm parcel priced at $326,500? Option A, 30 days from passing the examination. Option B, 3 years from passing the examination. Option C, until the next broker renewal cycle only. Option D, 1 year from passing the examination. The correct answer is option D, 1 year from passing the examination. Minnesota guidance states that the salesperson license application must be made within 1 year after passing the examination. Shorter periods such as 30 days are too restrictive, and longer periods ignore the retake requirement. The broker renewal cycle does not control the candidate's examination validity period. Question 81. When Reese, a licensee, intends to buy a client's property in Woodbury, what disclosure is required before negotiation or consummation? Option A. The licensee must affirmatively disclose the license status and the capacity in which the licensee is acting. Option B. The licensee may stay silent if paying full market value. Option C. The disclosure is needed only after the deed is recorded. Option D. Only the buyer's lender must be told about the license. The correct answer is option A. The licensee must affirmatively disclose the license status and the capacity in which the licensee is acting. A Minnesota licensee who acquires or intends to acquire an interest in real property must disclose the license status and capacity before negotiation or consummation. Paying market value does not remove the conflict risk, and post-recording disclosure would be too late. Lender-only notice does not satisfy disclosure to the property owner. Question 82. Why might Blair Nolan use a quitclaim deed to clear a possible title issue? Option A. It guarantees the property is free of every lien. Option B. It transfers whatever interest the grantor may have without making title warranties. Option C. It creates a new mortgage automatically. Option D. It replaces the need for delivery and acceptance. The correct answer is option B. It transfers whatever interest the grantor may have without making title warranties. A quitclaim deed can release or transfer any interest the grantor may have, but it does not warrant title quality. It does not guarantee lien-free ownership or create a mortgage. Like other deeds, it still depends on proper execution, delivery, and acceptance. Question 83. A contract substitutes a new party and releases the original party from liability. Which term best describes that change for Taylor and St. Cloud involving a fourplex priced at $352,500? Option A, assignment only. Option B, accretion. Option C, novation. Option D, hypothecation. The correct answer is option C, novation. Novation substitutes a new obligation or party and releases the original party when all required parties agree. Assignment transfers rights but does not necessarily release the assignor. Accretion and hypothecation involve land buildup and pledging property as security. Question 84. Which ownership estate gives Casey Lee the greatest bundle of rights with no stated end date or condition? Option A, estate at sufferance. Option B, life estate. Option C, license. Option D, fee simple absolute. The correct answer is option D, fee simple absolute. Fee simple absolute is the broadest ownership estate and can continue indefinitely. A life estate ends with a measuring life, an estate at sufferance arises from holdover possession, and a license is permission rather than an estate. The key phrase is ownership without a stated end date or condition. Question 85. In a gross lease for a Red Wing office, which cost structure is most typical for Rowan and Red Wing involving a lake cabin priced at $454,500? Option A. The landlord pays most property operating expenses from the rent received. Option B. The tenant pays all property taxes, insurance, and maintenance separately. Option C. The tenant receives title at the end of the lease. Option D. The rent is based only on retail sales volume. The correct answer is option A. The landlord pays most property operating expenses from the rent received. In a gross lease, the landlord typically pays most operating expenses and receives rent as a gross amount. Net leases shift more expenses to the tenant, and percentage leases tie rent partly to sales. A lease does not transfer title merely because it is gross. Question 86. During a first substantive contact with a residential consumer in Woodbury, what disclosure should the licensee provide for Riley in Woodbury involving a single-family home priced at $303,000? Option A. A final closing disclosure showing loan terms. Option B. An agency disclosure form explaining available agency and facilitator relationships. Option C. A county tax statement for the current year. Option D. A deed prepared for recording. The correct answer is option B. An agency disclosure form explaining available agency and facilitator relationships. Minnesota requires an agency disclosure form at the first substantive contact in residential transactions covered by the statute. The form explains representation choices and facilitator status before the consumer decides whether to enter a representation contract. Closing disclosures, tax statements, and deeds serve different functions later in the transaction. Question 87. An older commercial building in Duluth may contain asbestos insulation. What should the licensee avoid doing? Option A. Recommending qualified inspection or environmental advice. Option B. Disclosing known material facts. Option C. Giving a technical safety opinion beyond the licensee's expertise. Option D. Using written reports from qualified professionals. The correct answer is option C. Giving a technical safety opinion beyond the licensee's expertise. Asbestos concerns should be handled with qualified inspection and proper disclosure of known material facts. A licensee should avoid technical safety opinions outside the real estate role. Professional reports and disclosure are safer than speculation. Question 88. A Minnesota salesperson renewal fee includes a contribution to which fund for Cameron in Northfield involving a rental house priced at $300,000? Option A. Federal Flood Insurance Reserve. Option B. County Recording Technology Fund only. Option C. Private MLS Scholarship Account. Option D. Real Estate Education, Research and Recovery Fund. The correct answer is option D. Real Estate Education, Research and Recovery Fund. Minnesota salesperson license fees include an amount for the Real Estate Education, Research and Recovery Fund. Flood insurance reserves, county recording funds, and private MLS accounts are unrelated. The fund is part of the state licensing fee structure. Question 89. A facilitator working with Cameron in Maple Grove performs services without representing either side. Which fiduciary duty generally remains unless expanded by written agreement? Option A. Confidentiality. Option B. Loyalty to the seller only. Option C. Obedience to the buyer's investment goals. Option D. Advocacy for the party paying the commission. The correct answer is option A. Confidentiality. A facilitator does not act in a fiduciary capacity as a buyer's broker, seller's broker, or dual agent, but confidentiality remains a duty unless the relationship is expanded by written agreement. Loyalty, obedience, and advocacy belong to agency representation, not ordinary facilitator status. Commission payment does not create fiduciary representation by itself. Question 90. A buyer deposits earnest money with a broker in the form of a negotiable note rather than cash, What extra care is needed for Hayden and Brainerd involving a townhome priced at $362,500? Option A. The broker may throw it away because it is not cash. Option B. The non-depositable item must be handled through authorized escrow with written authority and proper records. Option C. It can be placed in the broker's personal safe without records. Option D. It automatically becomes commission income. The correct answer is option B. The non-depositable item must be handled through authorized escrow with written authority and proper records. Non-depositable items received as earnest money require careful escrow handling, written authority when the broker holds them, and proper records. They are not discarded, hidden as personal property, or treated as commission income. The rule protects all parties' interests in non-cash deposits. Question 91. A tenant with a disability asks for an assigned accessible parking space near the entrance. What fair housing concept is most directly involved for Schuyler and Blaine involving a small retail building priced at $391,000? Option A. Adverse possession. Option B. Yield spread premium. Option C. Reasonable accommodation. Option D. Defeasance clause. The correct answer is option C. Reasonable accommodation. A reasonable accommodation is a change in rules, policies, or services that may be needed for a person with a disability to use and enjoy housing. Adverse possession concerns ownership claims, yield spread premiums concern loan compensation, and defeasance clauses concern loan satisfaction. The requested parking change involves access to housing. Question 92. A licensee directs families with children only toward one area of Northfield. What fair housing problem does that conduct create for Cameron in Northfield involving a fourplex priced at $292,000? Option A. Amortization. Option B. Subordination. Option C. Novation. Option D. Steering. The correct answer is option D. Steering. Steering occurs when a real estate professional guides prospects toward or away from areas based on a protected characteristic. Amortization is loan repayment, subordination is lien priority adjustment, and novation is contract substitution. The conduct described limits housing choice and raises fair housing risk. Question 93. Wetlands are suspected on a vacant Clay County parcel. What should a licensee recommend before development assumptions are made for Reese in Edina involving a mixed-use property priced at $410,500? Option A. Obtain qualified advice about wetland restrictions and permitting. Option B. Assume all wetlands can be filled without approval. Option C. Use only the buyer's preferred building sketch. Option D. Ignore wetlands because they affect only personal property. The correct answer is option A. Obtain qualified advice about wetland restrictions and permitting. Wetland restrictions can limit development and require permits or expert review. Assuming fill is allowed or relying only on a sketch creates risk. Wetlands are real property and land use issues, not merely personal property concerns. Question 94. Which fiduciary duty requires a broker to keep client money and property properly accounted for Avery in Moorhead involving a rental house priced at $409,000? Option A. Assemblage. Option B. Decounting. Option C. Accretion. Option D. Divulsion. The correct answer is option B. Accounting. Accounting requires a broker to account for money and property received on behalf of a client. Assemblage, accretion, and avulsion are property or land concepts, not fiduciary duties. The key clue is handling client property and funds. Question 95. A seller says the basement is perfectly dry despite knowing of repeated water intrusion. Why is that more than ordinary puffing for Taylor and St. Cloud involving a duplex priced at $217,500? Option A. It is always protected opinion regardless of knowledge. Option B. It is allowed if the buyer gets a loan. Option C. It is a factual misrepresentation about a material property condition. Option D. It becomes legal if stated verbally instead of in writing. The correct answer is option C. It is a factual misrepresentation about a material property condition. A specific false statement about a known material condition can be misrepresentation. Puffing is general opinion, not a false factual claim about water problems. Financing approval or verbal delivery does not make a known material misstatement acceptable. Question 96. A buyer asks about radon during a Bemidji home purchase. What is the safest professional response for a licensee? Option A, guarantee that radon is never a concern in Minnesota. Option B, tell the buyer to ignore radon because it is a title defect. Option C, prepare a scientific certification without testing. Option D, provide required or available radon information and recommend appropriate testing or qualified advice rather than guaranteeing levels. The correct answer is option D. Provide required or available radon information and recommend appropriate testing or qualified advice rather than guaranteeing levels. Radon is an environmental concern that should be addressed with required information, testing, and qualified resources. A licensee should not guarantee levels or provide scientific certification without proper expertise. Radon is a physical/environmental issue, not a title defect. Question 97. A Minnesota landlord withholds a deposit for faded paint caused by normal use. Why is that deduction questionable for Quinn in Bemidji involving a vacant lot priced at $185,000? Option A, normal wear and tear is not a proper basis for withholding a security deposit. Option B, deposits may be withheld only for broker commissions. Option C, all paint changes are automatically tenant damage. Option D, the tenant must buy the property to get the deposit back. The correct answer is option A. Normal wear and tear is not a proper basis for withholding a security deposit. Security deposit deductions are for items such as unpaid rent or damage beyond ordinary wear and tear. Normal fading from ordinary use is not the same as tenant-caused damage. Broker commissions and purchase rights are unrelated to residential deposit accounting. Question 98. A St. Cloud buyer's loan has small monthly payments but one large final payment. What is that final payment called for Taylor in St. Cloud involving a rental house priced at $203,500? Option A, proration credit. Option B, the balloon payment. Option C, replacement reserve. Option D, equity dividend. The correct answer is option B, balloon payment. A balloon payment is a large unpaid balance due at the end of a loan term. A proration credit divides expenses at closing. A replacement reserve funds future repairs, and an equity dividend is an investment return measure. The structure described is a financing feature. Question 99. Under the Minnesota Human Rights Act, which protected basis expands beyond the traditional federal fair housing list for Kendall and Rochester involving a newly built townhouse priced at $279,500? Option A, preference for a short commute. Option B, owning two vehicles. Option C, status with regard to public assistance. Option D, having a fixed-rate mortgage. The correct answer is option C, status with regard to public assistance. Minnesota housing and real property discrimination law includes status with regard to public assistance among protected bases. Commute preference, vehicle ownership, and mortgage type are not protected classes. State law can add protections beyond the federal baseline. Question 100. Which fiduciary duty requires a broker to follow a client's lawful directions for Rowan and Red Wing involving a lake cabin priced at $418,000? Option A is cheat. Option B, novation. Option C, subordination. Option D, obedience. The correct answer is option D, obedience. Obedience requires following lawful client instructions. It does not require obeying illegal instructions or ignoring disclosure duties. Is cheat, novation, and subordination are unrelated legal concepts.